The O'Farrell government is committed to changing the way we deal with juvenile offenders in New South Wales. That's why we're currently undertaking reviews of the bail laws, the Young Offenders Act and the Children's Criminal Proceedings Act. The Department of Attorney General and Justice, in its juvenile justice function, have also been undertaking a policy review of the justice system in consultation with other agencies and community partners. And the O'Farrell government is consulting with the Aboriginal community and some of its leaders and representatives through its ministerial task force chaired by the Honourable Victor Dominella, with other people, members such as the Health Minister Gillian Skinner, the Treasurer Mike Baird, the Minister for Mental Health Kevin Humphreys, Minister for Community Services Prue Gowda and myself. I think that's it. Yes. And we're specialising in looking at the problems of education and work, getting work and training. We're also looking at other issues such as housing, health and justice. And they're all very important issues, and our ultimate aim is to devolve the power so that the Aboriginal communities themselves feel that they are really running the shot, not Macquarie Street. They're running the show. So we very much want to achieve that success. I know others have tried. There's been many attempts, but we're hoping a new approach will be successful. There's some startling statistics that I have to burden you with concerning juvenile reoffending. From 2001 to 2010, these have been recently discussed in the media. Among those who've had their first known caution, conference or court appearance in 1999, 53.7% were reconvicted in 10 years. In the 2010-11 financial year, the proportion of young people in detention in New South Wales of an Aboriginal or Torres Strait Islander background was 51.7%. This is despite the fact that Indigenous young people aged 10 to 18 make only around 3% of the New South Wales population. That is a tragedy and a disgrace, and we're doing our best to change it. These figures are appalling. We can and we must do better. The bail review I've requested reflects my consistently held concern that the current bail laws are having an adverse impact upon the juvenile remand population. Approximately 50% of young people in detention centres are held on remand and mixed with hardened offenders. There's very little segregation in juvenile detention centres, unlike prisons, where there is clearly a distinction between remand prisoners and the various classifications of sentenced prisoners. 82% of the young people in detention centres remanded in custody do not receive custodial sentences when finally dealt with. These are very concerning statistics, and we've got to turn them around. We want a justice system that is smarter. It's not softer, it's smarter. That's what we're aiming at, and deals directly with the reasons behind offending by young people. And the evidence shows us that young people in the justice system come from the most disadvantaged and sometimes dysfunctional backgrounds. They are disengaged from school and their communities and have high levels of drug and alcohol use. Clearly, we need to address issues within communities and families in order to reduce the risk of offending by these young people. Government agencies and community organisations need to work together much more than they have in the past to provide coordinated solutions to the community problems which lead young people into a life of crime. It takes courage and commitment to develop and implement innovative strategies to address youth crime in ways that are meaningful and achieve positive social outcomes. Early intervention and family and community involvement is essential. There are a number of programs operating in the justice system already, including the intensive supervision program that Juvenile Justice runs in the community with repeat offenders and their families, which goes some way to addressing this intervention. Dr. Don Weatherburn from the Bureau of Criminal Statistics and Research has emphasised the importance of evidence-based policy. He says that the evidence shows the best way to reduce juvenile offending is to address the underlying causes of juvenile offending, such as poor parenting, poor school performance, drug and alcohol abuse, mental illness and intellectual disability. And he had a letter in today's Sydney Morning Herald just clarifying a passage in the earlier article in the Herald which made it sound as though he was pushing for more imprisonment. He said he wasn't. He was pushing for sensible intervention and supervision so that generally outside the detention system, where mentoring and other things can be taken into account and help young people get a job, get training, get off their drug and alcohol problems, find a home and just turn up to work, which is a problem sometimes. And that's something that works with groups like Shine for Kids, which is running a program at the moment with a number of young children at Frank Baxter, where they have mentors that are there for meeting the young people for 6 months before they get out, and then work with them in the community when they get out as a sort of a buddy. And we're sure that that effort and similar efforts will be successful. Justice reinvestment is a strategy that will inform our current review of the juvenile justice system. The idea of diverting funds to programs and services that address the underlying causes of crime deserves support from every political party. Innovative ideas are now long overdue. It's time to take action to address this issue. I heard the Governor give one of her many wonderful experiential stories of what happened when she was working in the courts. I was prosecuting a number of people, I won't say who they were, and a famous Aboriginal leader, Shirley Smith, Mum Shirl, came to give character evidence for one of these persons. And when I cross-examined, I called her Mrs. Smith. And she intervened and she said, "Don't call me Mrs. Smith, call me Mum Shirl, that's my name, everyone calls me Mum Shirl." And the magistrate chipped in, "Well, I'm sorry Mrs. Smith, but he's also Mr. Smith. We don't have to call him Pa Smith, so he's not being disrespectful." In any event, it's something I'll never forget. It's a pleasure, and she was a great woman and did a great many things. And I see Linda Burney over there, who I thought made a very good statement and presentation on the 7:30 show last Friday about these problems, and I was heartened to hear it, not surprised, but great to hear it. It's a pleasure and a great honour to speak at this launch of the Justice Reinvestment for Aboriginal Young People campaign. I thank you for your service to the young people of New South Wales, as well as the dedication and support you've shown to such a worthy cause. Thank you.